same partner in the matter of Gordon, portfolio to Ethan Limited and Nata and Ruhan and others.
Mr. Figaro.
Good morning. Yesterday, to my enormous relief, we covered the whole of ground one of my appeal, and we were coming to the end of ground two. In the afternoon, I'm conscious I went quite quickly, so if I could just recap on ground one. Where there is one conspiracy, one scheme of wrongdoing.
Sorry, where there is one
conspiracy, one scheme of wrongdoing, where it could be said to be, as here, a composite transaction involving the making and the dissipation of the profit. The connection between the original fiduciary breach and its assistance, and the custodial breach.
Since you're trying to give us something that we might write down, could you just give a bit more? So the connection between the original fiduciary breach
and its assistance, and the custodial breach and its assistance, is such that the wrongdoing cannot be regarded as, or rather that the wrongs cannot be regarded as distinct and independent wrongs. That means that they cannot be cherry-picked by the claimant. In other words, in assessing the loss caused by the custodial breach and its assistance, one cannot disregard the profit, the fiduciary breach and its assistance. Putting the point in a rather more ponderous way, as I kept trying to do yesterday, in determining the counterfactual by reference to which loss is to be assessed, in other words, when determining the hypothetical situation in comparison with which loss is to be assessed, the hypothesis must include compliance with the original fiduciary duty. So although there may be a formal separation in terms of causes of action, there is not an independence or a distinction allowing the court to ignore the former in order to make a substantial award in respect of the latter. Now, Lords, yesterday, as my Lord and Lord Justice Males pointed out, my submissions were directed primarily at the fiduciary's position, the loss that he caused. But in my respect...
Sorry, just before you go on to what you're about to say, would another way of formulating what you've just been submitting, but using the analogy of set-off case which you drew to our attention, be to say that in assessing loss caused by the custodial breach and its assistance, you must also take account of the benefit obtained as a result of the original fiduciary breach and its assistance when the two breaches are so closely connected that it would be manifestly unjust not to do so.
Lord, I do say precisely that. Thank you.
And it's just an alternative formulation of
yes.
what you've been saying, I think.
I'll come to that case. What's interesting about it is it emphasises the need for a formal requirement and a substantive requirement. That may be the wrong distinction. And there is a similar requirement here. There has to be a formal connection, but the connection must be such that it is unjust, Mr. Justice Brightman said unjust. Other judges have said unfair, unreasonable, and unjust. Other judges have said artificial and unreal. All those formulations are getting at the same point. It must be wrong in the eyes of equity to allow a calculation to be based on the former without taking into account a calculation based on the latter. And, my lords, my submissions yesterday did focus on the position of the fiduciary, but the reasoning applies equally, and indeed in my submission with greater force, to the dishonest assistant. The difference between the fiduciary and the dishonest assistant is that the dishonest assistant is not accountable for the fiduciary's losses. One can see that, one might say in relation to the fiduciary, but there's a policy at work here that the fiduciary mustn't be accountable for his profit, must be accountable for his profits. That's not true of the dishonest assistant.
Just pausing there. I suppose until that was decided, this question would have been a rather academic one. Because if the assistant was going to be liable for the fiduciary's profit, you didn't need to work out whether there could be a compensation claim of the kind accepted by the judge.
My lord, yes. As I say, on this side of the court, we're not aware of a case in which that fact pattern has arisen.
I suppose what I'm just wondering is whether, well, that's not so surprising perhaps in circumstances where if it were thought that the assister was going to be jointly and severally or whatever liable for the fiduciary's profits, it really didn't matter whether there was a compensation claim that could run against the assister for the same amount.
I may not be grappling with your point. I
may not have thought it through, but it certainly was a theory that where a fiduciary made a profit and had been dishonestly assisted by somebody, the dishonest assister was jointly liable for the fiduciary's profit on a profit basis, not a compensation basis. And certainly in the circumstances of this case, supposing that it had been thought that Mr. Stevens were jointly liable for Mr. Ruhan's profit, you wouldn't have needed to work out whether there was a compensation claim.
Lord, I am not aware of an English authority which has posited the suggestion that a dishonest assister is jointly and severally liable for the fiduciary's profits. But I may not be grappling with your lordship's point.
I thought in the past that had been suggested.
It has been suggested by academics. It was considered, I'm going to come to this in fact, by Mr. Justice Lewison in Ultraframe. And he came very positively to the conclusion that it should only be for the dishonest assister's own profits. Perhaps we can wait until we look at that.
All I would say is that obviously was what Mr. Justice Lewison concluded, but I'm not sure that was generally viewed as a case, at least in advance of that decision.
It may be that I'm confusing myself with the Australian authorities, which have gone in a slightly different direction. Although not all that different, not as different as... There is no general principle, even in Australia, where they take a rather more rigorous view, more healthy view, or unhealthy view of my submission. Even in Australia, there's not a general proposition of that sort. In any event, I'm not sure I've assisted you on that question. I do apologise. On ground 2, as I said, my ground 1 applies both to the fiduciary, but even more so to the dishonest assistant. My ground 2 focuses on the dishonest assistant's liability. And here I say that in a single conspiracy or single scheme of wrongdoing case, the effect of the judge's conclusion in this case is to make all dishonest assistants to the making of the profit by the fiduciary automatically liable for those profits to the extent that the fiduciary has disposed of them.
Is ground 2, which is based on novership, really a dog that didn't bark point? Because the claim in novership was simply a claim for an account of profits held that you can only recover from the dishonest assistant his own profits. But it doesn't look as if there was a claim for equitable compensation, putting it this way.
Yes.
The court therefore didn't have to grapple with the point, and it's therefore a dog that didn't bark case.
My learned friend will undoubtedly make that submission. I would if I were in his position. It's juridically correct in the sense that the fact pattern that was faced by this court in novership is not the present fact pattern. My submission, though, is that the principles identified and adopted by the court in novership are directly applicable to the substance of this case, and to ignore novership. I say that, put that rather prejudicially, but to disregard novership on the basis that the facts were different, the situation was different, there was no constructive trust argument in play, would be, in my respectful submission, to overlook an important part of the principle upon which the outcome of that case was decided. Dishonest assistants should not be liable for the profits made by a fiduciary, however the claim is dressed up. And I do say this is a matter of dressing up because, as I say, of the close connection between the fiduciary breach and its assistance and the custodial breach and its assistance. But it is important to understand that not only should the principles apply, there's also a question as to what the court thought it was deciding in novership. In novership, the court thought it was deciding that where a dishonest assistant has assisted in the making of an unauthorised profit, the dishonest assistant ought to be liable. It ought to be possible for the court to decide that the dishonest assistant is liable to account for his profit. And by the same token, it ought not to be liable to account for the profit of the fiduciary. And indeed, this was a matter that my Lord Justice Mayles addressed in Lifestyle Equities, and I'll be coming to that very briefly. In those circumstances, what the court thought it was doing was ensuring a safe limit, a safe, reasonable, fair limit to the scope of the dishonest assistant's liability for profit. Put that neutrally. What the effect of the learned judge's argument below is that that safe limit is now gone. For the reasons I explained yesterday afternoon, I was going rather quickly because I was concerned about the time, but on the basis of Group 7 and the lax causation approach that's adopted in dishonest assistance cases, the effect of the judge's approach is that in all cases where a dishonest assistant has assisted in the making of a profit, that dishonest assistant is ipso facto liable for the whole of the fiduciary's profits to the extent that they've gone. So it creates a secondary liable in the dishonest assistant for all of the fiduciary's profits. And Lord, I do say that's contrary to what was the fundamental decision made by this court in novership. Your Lordships, excuse me. Would your Lordships just give me a moment? it's a very small point, but in the court below, Mr. Justice Foxton did find that Novership was authority for the proposition that a dishonest assistant could only be made liable for the profits which were caused by his assistant. And that's paragraph 265, subparagraph 1 of his judgment. There's no need to go to it. It's at page 188 of the core bundle. So that's where I'd got to yesterday afternoon. Our case on this side of the court is that that result is clearly not right. It's contrary to the principles of liability and indeed to basic principles of equity. And the question is how to avoid that problem. Our primary submission is that one should apply our distinct loss analysis, if I can call it that, for want of a better term, to all dishonest assistants who have assisted in the making of profits, whether or not they've also assisted in the, directly assisted in the dissipation of the profits. All of those people, in the case of all of those people, their liability for assisting in the making and the disposal cannot be passed. In other words, they can't be regarded as having caused a loss to the principal, even if the fiduciary can be regarded as having caused a loss because he was liable to account for the profits and he was a constructive trustee. In relation to profits, Novership tells us that dishonest assistants' liability is not coextensive with that of the fiduciary. It is the opposite of coextensive. And on that basis, my primary submission is that the judge should have held that the decision and the principles established by the decision in Novership precluded recovery of the hotel profits from Mr. Stevens, because they were not profits which he himself received, they were not profits in relation to which he owed a fiduciary duty, and they were not, and the loss of those profits cannot be said to be losses which his assistants can properly be said to have caused, or indeed the underlying breach can properly be said to have caused. Well, I have an alternative submission if that doesn't find favour with this court. My alternative submission is that where in substance the claim to recover a fiduciary's profits from the claim is to recover the fiduciary's profits from the dishonest assistant, in order to prevent the Novership principles from being subverted.
So I just go a bit more slowly.
I do go too fast. So where in substance the claim is to recover the fiduciary's profits from the dishonest assistant, in order to avoid that problem, it's necessary to apply those principles to the claim. Well, that's addressed in paragraphs 89 to 96 of our skeleton argument. May I ask the court to have a quick look at that? It's in divider 2 of the core bundle. And it's at page 43. And I invite the court to read paragraphs 89 to 96. Lords, that specific approach that I'm suggesting for the specific case of a dishonest assistant that is in substance sought to be made liable for the fiduciary's profits, that specific approach appears to conflict with the general approach to dishonest assistant's liability articulated in Grupo Torres and Casio Computer and all the later cases. But that general approach was decided in the context of cases in which there wasn't a claim in substance for the fiduciary's profits. This issue wasn't before the court in Grupo Torres. Moreover, that general approach was decided long before the development of the law made by this court in Novoship. And just as Novoship has developed the law in relation to dishonest assistant's liability for profits, so it's appropriate for this court to further develop the law to reflect the logic of that approach. Now, my lords, could I just pick up some outstanding matters from yesterday as quickly as I possibly can? I handed up a case called Geldof Metall Constructi yesterday evening. Since then, some further authorities have been handed up. The case of Byers that my Lord Justice Newey referred to, an article by Professor Worthington on the Auden Mackenzie case, again, which my Lord Justice Newey referred to, and my Lord Justice Mayall's decision in Lifestyle Equities.
No, not mine. My Lord
Did I say Mayall's? My Lord Justice Birss's. Your modesty does you great credit, my lord. Could I start with Geldof? I'll be extremely quick. It was a straightforward equitable set-off case. There was a contract for the purchase of some equipment and a contract for the installation of that equipment. There was a claim for the purchase price, which was met by a cross-claim for failure to install, and the question of equitable setup arose. As a result of, in that situation, it was necessary for the court to consider the jurisprudence relating to equitable set-off. And there's a very interesting discussion from Lord Justice Ricks at pages 903 to 914 of the report. You'll be relieved to know I'm not going to invite you to read all of those pages. One picks up the principle that was decided at paragraph 1 of the headnote on the second page of the document, page 896 of the report. And perhaps I could invite you to read that. It won't come as any surprise. One point is worth me specifically mentioning. It's at page 906 of the report. It's the discussion in paragraph 28 and following of the decision of the House of Lords in Bank of Boston, Connecticut and European Grain and Shipping Limited. It was a case in which the question of equitable set-off was raised. And if I could pick it up in paragraph 29, my lord, at the end of the first line, Lord Brandon had in fact gone out of his way in the course of his speech to displace the impeachment rationale of Rawson and Samuel. He said it was necessary to explain briefly the nature, origins and basis of a defence by way of equitable set-off. Making no express mention of Lord Justice Morris's judgment in Hannock and Green, nor of the Nanfrey, he reached back to see whether such a cross-claim is of such character that it would, before the coming into force of the Supreme Court of Judicature Acts, have led a court of equity to prohibit by injunction the enforcement of the common law claim. Stopping there, it's helpful to remember quite how aggressive the jurisdiction assumed by a court of equity was, where one was talking about legal cross-claims, where a common law court would only allow a set-off where it was a case of mutual debts. The court of equity would say, no, that offends our sense of justice. The connection between those claims is so great, we're going to grant an injunction stopping one of the claimants from proceeding with his claim before the King's Bench without giving credit for the other claim which he faces. So, Lord, just as that's an extraordinary jurisdiction if one thinks about it, our case is much less extraordinary. It's a case where two claims are being considered, and the question is whether they should going the same way, and the question is whether they should be considered at the same time. But one can see that there's an analogous situation, and if there's going to be interference by equity in the case of a claim and a cross-claim, it would be surprising in my submission if a court of equity wouldn't do the same thing when there are two claims going the same way. And then if one goes on in the judgment, he referred to Rawson and Samuel as the authority most relied on as providing the relevant test. However, he rejected that test as of continuing use in the modern world in the following passage. The concept of a cross-claim being such as impeached the title of the legal demand is not a familiar one today. That was the old test. A different version of the relevant test is to be found in the decision of the Judicial Committee of the Privy Council in Government of Newfoundland and Newfoundland Railway. It is to be observed that the criterion which Lord Hobhouse applied in deciding whether the government's cross-claim for unliquidated damages could be set off against the company's claim was not that the cross-claim impeached the title to the legal demand, as in Rawson and Samuel, but rather that it was a cross-claim flowing out of and inseparably connected with the dealings and transactions which also give rise to the claim. Well, Lord, I say that formulation applies to this case with absolute precision. Indeed, it does so in much the same words that I've already used yesterday to describe it. So those are my submissions on equitable set-off. And for your Lordship's note, that was raised by my Lord Justice Mayles at page 44 of the transcript. If I could move on to a point that was raised by my Lord Justice Newey at page 105 of the transcript. This was related to buyers in Saudi National Bank, a decision of this court in 2021. Lord, that was a case which addressed the problem, what happens when a person receiving property who would in another case be considered a knowing assistant, what happens if the effect of the law governing the property rights means that once the minute the knowing assistant receives the knowing recipient, receives the property right of the claimant extinguishes itself. In other words, the question considered was whether there was a need for the property law governing the property in the shows, whether there was a need for that property to continue even after the receipt by the recipient. And this court decided there was such a requirement, such that if the title was extinguished, that was an end, that precluded any knowing that receipt claim. Lord, if I could pick it up at page 6 of the judgment. This is the judgment of your Lordship. Should have known that. Your Lordship, page 6, paragraph 23. There is, however, your Lordship says, there is, however, no requirement that a defendant should still have the property in question by the time a knowing receipt claim is brought. In fact, such a claim is most obviously likely to be useful where the defendant no longer has the property. If the defendant yet retains the property, the claimant may be able to recover by asserting a proprietary rights rather than by making a personal claim for knowing receipt. And then the analysis goes on. If we could pick up your Lordship's judgment at page 11. In paragraph 47, your Lordship said the previous paragraph of Sir Terence Etherton's judgment is of more significance than paragraph 38. Sir Terence then said, The recipient's personal liability to account as a constructive trustee by virtue of knowing receipt means that the recipient is subject to custodial duties which are the same as those voluntarily assumed by express trustees. And there's a reference to Charles Mitchell and Waterson's book or chapter. Well, stopping there, that was what I was trying to say yesterday, but I said it in such a general way that I can quite understand why your lordship drew back. I was not seeking to suggest that the knowing recipient had any kind of management duties. If the knowing recipient receives property and doesn't look after it, and as a result it depreciates in value, the knowing recipient isn't liable for the difference. That's not the nature of its obligation. Its obligation is essentially a custodial one. And that's the point that's made in the passage your lordship then cites in paragraph 48. Where you say, just under the quotation, the recipient's primary duty, and generally his only duty, is to restore the property immediately so that the trust can be reconstituted and duly administered. And to the extent I gave the impression I was saying anything different, I'm happy to confirm that wasn't my intention. I did speak too loosely. Well, the third outstanding point arose at page 134 of the transcript, and this is Professor Worthington's article, case note really, on Orden Mackenzie. Lord, it's worth reading the entire article, and I don't have time to take you to it completely, but could I just draw out some points? In the second page of the handout, that's page 221 of the Cambridge Law Journal, second paragraph down, she makes the point, about halfway down the paragraph, no one disputes that fiduciaries such as Patel may be subjected to money remedies for three broad categories of breaches: unauthorised disposal of the assets under their management, wrongful management of those assets, and disloyalty, i.e. profit-generating breaches of the fiduciary's duty of loyalty. Now, my learned friend seeks to submit to your lordships, this is purely an unauthorised disposal case. I seek to submit to your lordship, you can't look at the disposal without looking at the disloyalty. She then says, in the next paragraph, Patel's breach clearly fell into the first category. This was also the relevant category in Target and AIB, and is unquestionably the most troubling category. The confusion is surprising, especially given the clear assertion in AIB that any analysis of remedial consequences must start with a precise understanding of the obligation which has been breached and the detailed performance requirements demanded by it. Lord, I do emphasise that. That exactly points up my submission, which is that one has to assume proper compliance of the relevant obligations. And I say the relevant obligations include the obligation not to make a secret profit in the first place, if I'm allowed to put it in that rather tendentious way.
Does that depend on the telescoping?
Does that depend on the
telescoping? I mean, you say, well, we look at it all as a whole. Supposing Mr. Pickering were right that we look at stage 2 separately and what the fiduciary should then have done, well, he should have handed over the property.
Yes. Then I have a problem. I accept that. But just as in the old days, the Court of Equity would have intervened to prevent cross-claims that were unconnected, that weren't direct and weren't mutual debts being asserted independently. So I say equity would your lordship has my submission.
Yes.
It then follows, she says, it then follows ineluctably that the value difference between the actual flawed performance and the hypothetical compliant performance indicates the quantum of equitable compensation, subject only to what is said below on timing. Again, so the question is, what's the hypothetical compliance performance? And your lordships have my submissions on that. It's performance of the original fiduciary duty, not just performance of the custodial duty. Lord, the same point is made. She then runs through a series of reasons that are sometimes given for the equitable debt type argument, the dissentience argument. And in my respectful submission, she very convincingly demolishes them, as she does in her article that's in the bundle. But on page 222, towards the bottom of the page, she says two conclusions emerge very clearly from this. First, there's no suggestion in either Target or AIB that those courts are qualifying or relaxing the previously strict application of the obligation of a trustee to restore to the trust fund the value of any assets transferred. Indeed, to the contrary, the relevant rule never was invariably to put back the value of what had been taken out. It was to put back the value of what should have been there. And my Lord, if I may say so, I commend that way of looking at things to this court. See, that's exactly my case. And then over the page at 223, about 2/3 of the way down, halfway down the second complete paragraph, she says, this is when considering the narrow submission and the court's decision not to make a decision on the narrow submission. She says, it is one thing to ensure practical justice in assessing the proper scope of a fiduciary's duty and the appropriate counterfactuals to assess losses or gains, but it's quite another to relax the traditionally strict duties imposed on fiduciaries in their management of assets on behalf of others, and especially to do so for reasons that are conceded to have no bearing on the assessment of liability. Lord, again, I commend that to your lordships. What needs to be done is to identify the appropriate counterfactuals by reference to which to assess gain or losses, and your lordships have my submission on how one does that. More final outstanding point.
Presumably, as a general point, you have some sympathy with what she says in the first sentence, the second paragraph on the first page.
On that page. That is why Patel's brought
No,
us.
on the first page, putting equitable in front of compensation seems
Well,
the right part.
I'm slightly less sympathetic towards that. Your lordships will be surprised. But I have to accept that merely because one uses the word equitable doesn't give you the right to sit under a palm tree. I'm seeking to identify a principled basis for acting. And I say Mr. Justice Brightman's approach in Bartlett and the later cases do provide that principled basis.
Just before you move on, can I just sort of confuse myself and everybody else by something we touched on yesterday? But I'm sort of prompted to think about it again by some of this. So, as Professor Worthington says, three broad categories of breach: unauthorised disposal, wrongful management, disloyalty. Now, where you have a fiduciary taking money which is not authorised, that's one category. But as you say, that's only asserted at stage 2, not at stage 1 in this case. So what we're concerned with here at stage 1 is disloyalty, where the principal can claim the profits if they choose to, and if they choose to do that, then retrospectively the profits are subject to a trust. On the judge's approach, you can choose to opt for the account of profits such that the profits are retrospectively held on trust, but then separately, presumably, assert a claim for breach of that trust. Now, on a buyer's type basis, the duty that the fiduciary would have in relation to the trust which had then retrospectively been recognised would have been a duty to hand over the money.
Yes.
Which rather suggests that when you opt for the account of profits, you can't complain if the profits have gone down in value in some way. You're stuck with whatever they happen to be. You can't.
Not if they've been disposed of.
No, that's true. But you can't complain that the profits have been mishandled,
Absolutely, and that's
mismanaged, they
another
haven't been
discussion we
effectively
had
invested.
yesterday. Yes.
Your complaint is that they haven't been handed over.
Yes.
Which sort of suggests that you take the profits as you find them, if you see what I mean.
Yes.
I quite follow.
I believe that was how I put my submission.
Yes.
Precisely yesterday. Yes.
Then I'm a bit troubled by the idea that you can do this two-stage approach. Say, look, I'm going for the profits, but then there's a separate liability to pay compensation for what has been done in relation to the trust that has now sprung into being with your claim to the profits. And supposing that the fiduciary could not at stage 2 be liable independently for breach of the trust that has now sprung into being, then there would be no compensatory liability that the assistant could be parasitic on, if you see what I mean.
I do hate to put words into my learned friend's mouth, but I'm sure my learned friend would say in answer to that question, there's no management duty. So if the fiduciary makes a profit but doesn't make as much as any sane, clever individual would, but in fact he makes a hopelessly low profit, it wouldn't be open to the claimant to say, well, you should have made more. It might be open to the claimant to say, if I'd had the money, I would have made more. But that would be a compensatory claim. But it wouldn't be open to the claimant to run a management type breach of trust claim against the constructive trustee.
No.
However, it would be open to the claimant to make a custodial breach of trust claim. It would be open, therefore, to the... I mean, this isn't in my interest to say this, but it would. I have to accept.
And what's the authority for that?
But the constructive trust is a custodial trust. There's an obligation to pay what you hold over to the claimant, and if you don't, you're in breach.
But it's sort of circular. There's only a trust at all because you opted for profits.
Yes.
So you opt for profits, and then you complain retrospectively that they haven't been handed over. But you don't need to do that. All you say is, "Look, I've opted for profits. I'll have the profits." Please.
Well, look, that was where I was trying to get to yesterday morning. That in terms of the fiduciary's liability to account for his profits, the custodial duty he has in his capacity as a constructive trustee adds precisely nothing. But he's already liable for those profits.
What worries me is whether there's a more fundamental objection, which is you can't complain of a breach of the custodial duty because you have a choice. You either... I'm not saying this is right at all, and there's probably lots of authority otherwise, but I'd like to be shown it. If you opt for profits, you get the profits. And then retrospectively, a trust comes into being, which may have tracing consequences and so on. But I just would like to be shown authorities the effect that if you opt for profits, such that now the trust comes into being, you can independently assert a compensatory claim for failure to hand over the profits in circumstances where there's no obvious legal need for there to be such a claim.
Well, my lord, I must confess, I mean, as I submitted to your lordship, on this side of the court, we're not aware of a case in which a claim has been made for compensation for breach of the constructive trustee's custodial duty. We're simply not aware of a case of that kind. It maybe my learned friend could assist you.
Yeah.
But what that throws up in my submission is there are questions. I mean, it's the question your lordship's asking. Of course, there are questions as to how whether it really is appropriate simply blithely to treat a claim for compensation for breach of the constructive trustee's custodial duty as if it were entirely unconnected with the liability to account, which is, and as if the liability account were in turn entirely unconnected with the fiduciary duty, which creates in fact, which is the liability to account. It constitutes the liability to account.
And just confusing everybody a moment longer, assume that it's right that where you claim profits and retrospectively bring the trust into being, you can then claim compensation for failure to hand over the profits. it's not immediately obvious what that claim amounts to. I mean, supposing the money was still sitting in a bank account, and you say, well, I'm complaining that your breach in failing to hand it over. Is the loss that you assert all the money, even though the money in the bank account is still held on trust for you?
That's a question I confess I haven't considered. I mean, the ordinary obligation of a trustee is to, if he's got assets that belong to the trust, is to account for those assets to the trust, as it were.
Yes.
And if he doesn't, he'll either be under an obligation to produce those assets in specie, or he'll be under an obligation to make a money award in substitute for it's my learned friend's substitute for compensation.
Then we go back to substituted compensation.
On which you have my submissions. I'm not sure I've entirely I've done myself justice with my answers to your lordship's questions.
I follow the substitutive type point, but in another sense, I mean, normally you would not need to work out what loss the fiduciary had caused by failing to hand over the money, because you're just claiming it all.
Yes.
You're claiming the profit. But if you do want to isolate what loss has been caused by failing to hand over the money to the principal, you might think you have to take into account what rights you've got.
Lord, I need to think about that. May I perhaps address that in reply? I could see the force of your lordship's submission, and indeed it does arise on my learned friend's substitutive case. So what would really please me if your lordship would give him that question and then see what he says. But if I could have some time to think about it, and perhaps if your lordship would raise it with me again in reply, that might be a convenient course.
Is there no duty under the custodial obligation to look after or take care of the asset? I mean, suppose to take my lord's example from yesterday, you turn the wall into a painting. Are you not under some obligation to look after it so that it's not damaged?
Well, Lord, that question it did arise in. I say it did arise. That's something which my Lord Justice Newey did talk about in the context of knowing recipients in the Birss case. I mean, what he said in Birss, and it's reflected in the decision of the Supreme Court in Williams and Central Bank of Nigeria, which is the leading authority on limitation actions. It's believe it or not, there's a case that's relevant here that's not in the bundles, which is that the essential liability of the knowing recipient, once he has the assets, is to pay them to the beneficiary, and that's it. And there is no sort of ongoing management obligation, such that one can't run the kind of argument I posited of a fiduciary making off with £100 million and making £2 million profit on them over 10 years, and then the beneficiary saying, well, if I'd had that money, I could have made 150 million out of it. You failed to make 48 million, you therefore owe me 48 million. If the beneficiary elects for a profits claim, it takes the errant fiduciary as it finds him, and it therefore is forced to accept the 102 million. However, of course, it has the option of making a compensation claim, but the compensation wouldn't be for breach of some sort of management duty in relation to the 100 million while it's in the possession of the fiduciary. It would be a compensation claim based upon the loss that the claimant has actually suffered as a result of being out of his money for 2 years.
Can I just add one thing? I mean, as I say, Birss has been in the Supreme Court recently. The rival view, or at least a rival view, is that there's no need for the recipient to have trust property as such at all, and there is no trust at all. Therefore, there is no custodial duty. A claim for knowing receipt is simply a money claim. There is no trust. And plainly, with dishonest assistance, there need be no trust.
Look, if that were the analysis, then the entire custodial breach part of my learned friend's argument would fail in relation to if Cambulo had been a knowing recipient. I apprehend that
Well, it
it
depends
wouldn't
what you
fail.
mean by knowing recipient, but
It wouldn't fail. I'm sorry to talk over you, but it wouldn't fail as regards Cambulo. I'm sorry to say this; it's not in my interest because Cambulo was a nominee. So Cambulo was effectively Mr. Ruhan and was therefore a Category 1 constructive trustee. It was a real trustee.
I absolutely follow that. No, I entirely understand that. But in terms of what have been called constructive trusts by way of dishonest assistance or knowing receipt, arguably, or on one view, the word trust doesn't come into it at all, really. They're just formulae for equitable relief.
Exactly.
Or
Yes.
Millet, I think so.
There's many cases cite that very famous dictum of, I forget who the original words came from.
Yeah.
It's a 19th century phrase. I don't think it was Barnes and Addy, but in any event, yes, your lordship has about as many points as I'm capable of making in that area, I think, at the moment. May I finally, given the time, very quickly go to lifestyle equities, if your lordship has it. May I express my gratitude to my Lord Justice Birss for raising it. In my submission, it's helpful in my analysis. This was a case of essentially a trademark infringement and passing off claim by a company. And it was a claim for the profits made in respect of those infringements. The company had gone into liquidation and wasn't worth powder and shot. So an attempt was made to make the directors liable to account for profits. And the question was whether they were liable to account for the company's profits or whether they were liable to account for their own, only liable to account for their own profits. This court decided that they were only liable to account for their own profits. If I could ask your lordships to go to page 1025 of the report, picking it up at paragraph 9. This is the judgment of my Lord Justice Birss, and who says, as the judge did, I start with Hotel Cipriani. In that case, Miss Justice Briggs was dealing with the liability of an accessory in an account of profits in a trademark case. And then he cites a passage from that case, which we don't need to look at. He says that was, in paragraph 10, that is a clear conclusion in favour of the finding that the accessory is liable to account for their own profits, not for those of the principal. Then we pick it up at paragraph 11. Next, I refer to the conclusion reached by Mr. Justice Lewison in Ultraframe. That was a case about dishonest assistance and breach of fiduciary duty. After hearing full argument, there's an understatement, and addressing a Canadian case which went the other way, and an unreported decision of Judge Seymour in Comax Secure Business Services, Mr. Justice Lewison held as follows. Paragraph 1600. I would have taken your lordship's this passage if I felt I had time, but now I can't resist. I can see that it makes sense for a dishonest assistant to be jointly and severally liable for any loss which the beneficiary suffers as a result of the trust. I can see also that it makes sense for a dishonest assistant to be liable to disgorge any profit which he himself has made as a result of assisting in the breach. However, I cannot take the next step to the conclusion that a dishonest assistant is also liable to pay to the beneficiary an amount equal to a profit which he did not make and which has produced no corresponding loss to the beneficiary. As Lord Justice James pointed out in Vyse and Foster, this court is not a court of penal jurisdiction. It compels restitution of property unconscientiously withheld. It gives full compensation for any loss or damage through failure of some equitable duty, but it has no power of punishing anyone. In fact, it is not by way of punishment that the court ever charges a trustee with more than he actually received, or ought to have received, and the appropriate interest thereon. It is simply on the ground that the court finds that he actually made more, constituting monies in his hands, hadn't received to the use of the SETI Key Trust. And then going on at paragraph 12, Mr. Justice Lewison's conclusion was followed by Mr. Justice Christopher Clark in Novoship. Novoship was another fiduciary case. It went on appeal. There is some support for the same view at paragraph 77 of the judgment of the court, but this point was not addressed specifically in the appellate court. Well, I would respectfully suggest it was addressed. The decision was made that it's only liable, but I quite see why your lordship put it that way. Your lordship didn't need to say anything else.
I'm not sure I did, but anyway, there it is. I agree.
And then you refer to the authorities. Those are the authorities against lifestyle. Then you read, you refer to the authorities relied on the other side, and your conclusion is at paragraph 15. A number of other cases were mentioned below and before us, but they do not advance the issue. The position is therefore that there's no authority on the point binding this court. The judge below held that the balance of authority in this jurisdiction was against Lifestyle's case, and in any event he agreed with the reasoning of Miss Justice Briggs, Lewison and Clark in the cases referred to. I agree with the judge's conclusions. The conclusion follows from the nature of the remedy of an account of profits itself. The liability to account for profits is a liability to account for the profits that the person liable has actually derived from the wrongful conduct which has made them liable in the first place. That accords with the equity of the situation. Lord, I respectfully pray that in aid. Of course, a dishonest assistant hasn't received any of these profits. And then paragraph 17, could I just pick it up halfway through? I hope I'm not doing your lordship an injustice by ignoring the first half. But you talk about Cipriani, and then you say, just under the letter E, sentence beginning, if the legal principle is as Lifestyle contend for, does it mean that the claimant is never entitled to the profits actually made by the accessory and is always and only entitled to claim from the accessory a sum equal to the principal's profits? That does not make sense. Moreover, I cannot see any justification for a conclusion that the claimant could obtain from the accessory both the profits made by the principal and the profits made by the accessory. Nor can I see any good reason why the claimant would be entitled to choose which of the two profits to recover from the accessory. These difficulties do not arise if an account of profits is confined simply to being an account of the relevant profits actually made by the person giving the account. Lord, I can't, if I may respectfully say so, I can't add anything to that, and nor do I need to. That completes ground two, and I see that I've gone rather longer than I intended. Could I now address the question of compound interest? And I hope your lordships will allow me to go quite quickly.
Yes.
Because I don't want to go over the short adjournment. The starting point for this ground of appeal is there is House of Lords authority regulating the cases in which compound interest in equity can be awarded. That case defines the scope of the jurisdiction to grant compound interest. Those cases do not include a claim for dishonest assistance. There are a few recent authorities at first instance awarding compound interest against a dishonest assistant, and these are largely based on a brief comment made by Lord Mance giving the judgment of the board in a Privy Council case, Conti Corp. In the present case, the judge decided to follow those authorities. See paragraph 40 of his consequentials judgment. No need to look at it, but for your lordship's note, it's in the core bundle behind divider 8 at page 231. But the problem is the Privy Council cannot overrule the House of Lords. Moreover, with the greatest respect to Lord Mance, properly understood, his brief comments in Conti Corp involve reasoning which was unsound. In my respectful submission, neither Conti Corp nor Novoship, which is the case upon which Lord Mance based his judgment, provide any basis for refusing to follow binding authority, that the court can't grant compound interest in this case. So this appeal raises a question of principle. We say it's settled at the highest level that a court of equity can only award compound interest in two cases. The first is where money has been obtained and retained by fraud. And the second is where money has been withheld or misapplied by a trustee or anyone else in a fiduciary position. Mr. Stevens, my client, is not within either of these categories. Now, before considering the jurisdiction, the circumstances in which equity allows compound interest. It may be helpful if I could be clear about why the Court of Equity allows compound interest. For that purpose, I'd respectfully like to show you Wallersteiner and Moir, even though I know that you will have seen it many times before. It's in Bundle 1, behind Divider 6. The facts are too well known to need summarising. Could I ask your lordships, to save time, could I simply ask your lordships to read certain passages from the judgments of Lord Denning and Lord Justice, gosh, I forgot his name, Buckley, I'm so sorry. If we could go to page 189, and if I could ask your lordships to read, it's page 388 of the report, from the letter B down to the bottom of the page, B to H.
Yeah.
So, two reasons are given by his lordship. The first is, first point worth making, interest is awarded awarded by way of punishment. If I may say so, there's one can see a distinct parallel between that point that was made and the same point being made by Mr. Justice Lewison in Ultraframe in the passage my Lord Justice Birss cited in the equitable lifestyle case. But because fiduciaries are not allowed to make a profit, it means that if a compensation claim is made for misappropriated funds, the court ensures that the fiduciary does not get away with repaying simple interest, having made a compound profit. So it doesn't get away with keeping a little extra secret profit for itself. In that situation, to prevent that from arising, the court awards compound interest. And the phrase, it's important to see, the phrase that the Master of the Rolls makes at the end, but just by letter E, he refers to it as, he is liable to account for that profit or interest in lieu thereof. So interest can be seen as a means of grappling with the fact that the errant fiduciary with the property or funds in his possession will have made a compound type profit. And although the claim is for compensation, given that he's got the fund in his possession and he's making use of it, compound interest is designed to ensure that he isn't left with a profit, even having paid the money back and paid simple interest on it. So there are 3 points that derive from that. First of all, this rationale naturally correlates with the second category of case I identified to your lordships. That is where money is withheld or misapplied by a trustee or anyone else in a fiduciary position. And it's important to notice that because that's, to the extent that compound interest is awardable in this case, it could only be because the dishonest assistant's position is analogous to the position of such a trustee or fiduciary. That's the first point. The second point is that in this scenario, equity awards compound interest because the trustee or fiduciary is subject to a special rule or disability. He absolutely must not be allowed to make a profit. Thirdly, the purpose of the award is to strip the fiduciary of the profits he would have made, or it's deemed that he might have made, on the money he's made use of. it follows that there's no warrant, in fact, there's no room to grant compound interest in circumstances where the relevant money has not been withheld by the fiduciary, not least because he cannot be presumed to have made use of the money in a profitable way in those circumstances. So
you say that the presumption that the fiduciary has, in fact, used the money to make the profit is one which doesn't apply to the non-fiduciary dishonest assister.
It doesn't apply to someone who actually doesn't have the profit, doesn't have the money in the first place. If the claim is made in respect of a fund, and the concern is that the fiduciary has made a profit from the fund, you can't grant compound interest on the fund against someone who never had the fund in the first place. To do that would be, in my respectful submission, a category error. This is a phrase I often use in a further attempt to demonstrate how clever I am. The second justification for awarding compound interest identified by Lord Denning is that the wrongdoer deprives a company of money it needs for use in its business. Now, this rationale naturally correlates with the first category of case in which compound interest can be awarded, namely where money has been obtained and retained by fraud. Now, the important point to remember, however, is that compound interest is not generally available against fraudsters. Clearly, the defendant's use of the money is relevant. Why is it relevant, I ask, forensically? My answer would be because there is this sense that the fraudster's out there making money on the money, and an award of compound interest would be appropriate, because otherwise there's a risk that that person would be allowed to keep some of his profit.
I mean, that's not exactly how Lord Denning explains.
That's absolutely not what he says. That's my suggestion.
Yes.
But it's not necessary for your lordships to come to any view on that side of things, because we're not in that category either. If we could pick it up at page 198 of the bundle, the judgment of Lord Justice Buckley. And if I could ask your lordships to read from letter C all the way down to letter G. Here, the learned Lord Justice explicitly bases his analysis on the second category in which compound interest can be awarded, that is the fiduciary category. Again, he adopts the in lieu of profits approach adopted by the Master of the Rolls. The intention in making a compound interest award is to make an award which ensures that the fiduciary is stripped of all profits that he is capable of making on the fund that's been misappropriated. Lord, there is a third judgment by Lord Justice Scarman, but he doesn't grapple with the juridical basis. But in my submission, that is what's going on when an award for compensation, compound interest is made. Let's now consider the circumstances in which such an award can be made. Lord, the old cases, and there are a lot of them, in which compound interests were awarded in equity were reviewed by the House of Lords in a case called President of India and La Pintada. It's in the bundles. I'm not going to invite your lordships to look at it, but it's in the first of the authorities bundle behind Divider 12. And the leading speech is by Lord Brandon. And he makes clear that the old cases established that there are two cases in which compound interest can be awarded. There are two cases where there is jurisdiction to make an award of equitable compound interest. One is where the money has been obtained and retained by fraud, and the other is where money has been withheld or misapplied by a trustee or anyone else in a fiduciary position. Lord, that was the first case in which the House of Lords considered the point. The second case is the case with which we're all familiar, of course. It's in Bundle 2. It's Westdeutsche Landesbank. Could we look at that? Bundle 2, behind divide 14. This was a very powerful attack on what were suggested to be historical and unreasonable constraints on the equitable jurisdiction to award compound interest. And it was a powerful attack made before a very powerful panel. The essential argument of the attackers was that time has moved on. In modern conditions, and in order to allow the claimant to obtain full vindication of his rights and full recompense, equity should have a general jurisdiction to award compound interest when appropriate, even in relation to a common law claim for restitution. Lords Gough and Wolfe agreed with this view. Times have changed. And it's a blot on the law that the jurisdiction should be limited that much. However, they were in dissent. They were dissenters. The majority cleaved firmly to the existing authorities, holding that because Parliament had twice considered the award of interest in the previous decades, it would be a usurpation of Parliament for the courts to extend the equitable jurisdiction by judicial fiat. If I could pick it up in the headnote, it's on page 569 of the bundle. It's the second holding. Perhaps I could invite the court to read that. In summary, that's that. It's a matter of constitutional significance. If anyone's going to change the law now, it's for Parliament to do it. And if we go to the judgments of the majority, the leading speech is that of Lord Brown-Wilkinson. It's at page 600 of the bundle. Perhaps I could pick it up at page 599. Could I invite your lordships to read from, it's page 700 of the law report, from the letter H on page 700 through to the letter, the letter E on page 702. So it's a page and a half, please.
Yeah, I'll do that.
So in my submission, his lordship is plainly adopting the analysis of Lord Brandon in La Pintada. There's the fraud case, or there's the fiduciary case. And as he makes it clear that in the fiduciary case, it's the purpose of the jurisdiction, the function of the jurisdiction. This is the point he makes on the last page, just underneath letter D. The purpose is to recoup from such a defendant an improper profit made by him. I ask forensically, profit on what? Answer, the profit that he's received. Sorry, the amount of money, the trust asset that he's received. The model is of a fiduciary obtaining a trust asset wrongfully, having the use of that asset so that he can make money out of it. A claim for compensation is made. This isn't an award which is made in relation to an account of profits. This is a claim to interest on compensation that's been awarded by the court. But when a claim to compensation is made for loss of the asset, as well as awarding compensation in the amount and the value of the asset lost, you also award compound interest to ensure that the net result is that the defendant isn't in a position where he might actually be left with a secret profit on top of the payments he's made back to the claimant. And Lord Slynn deals with the point at page 617 of the bundle. Perhaps I can invite your lordships, in the law report it's page 718, I can invite your lordships to read from the letter E on that page over to letter B on the next page.
Yep.
Well, in fact, to letter C. It's his entire speech. Your lordships will see that Lord Slynn's emphasis was on the constitutional point, that the matter has been in the hands of Parliament, as it were, twice in previous decades, and in those circumstances, it really meant that it was no longer within the purview of the courts to start reconstructing the rules governing the award of interest. The Parliament has seized itself of this field, and in those circumstances, the courts shouldn't start redrawing the goalposts, if I can put it that way. And then final speech of Lord Lloyd, that's at page 639. It's very short. If I could just invite your lord, it's page 740 of the law report. If I can invite you to read from the letter B down to well, actually, the next page as well, down to the letter F. So it's that two-page section.
Okay.
Lord, my submission is that's that. And it ought to be possible for your lordships to stop reading at this point. This is now a matter that's within the hands of Parliament. It's not for any court, whether this court or even the House, even the Supreme Court, to rewrite the rules relating to the jurisdiction to award compound interest.
I suppose you could say that there have been 2 further parliamentary interventions since these cases, at least 2 that I can think of, probably maybe more.
Lord, that may well be possible.
One is the Arbitration Act, which does give arbitrators the power to award compound interest, but says nothing about the courts. And the other is the Late Payment of Commercial Debts Act, which again deals with the award of interest in specific situations.
I'm obliged for that indication, my lord. I wish I'd thought of the point myself. But yes, in my submission, that reinforces the fact that this field is now Parliament's field to play with. It's not the court's field.
How would it work if a case arose in which the fiduciary was liable to was the election to be made and the fiduciary was liable to pay equitable compensation to the principal and compound interest on it, but there was then a dishonest assistant to that fiduciary who was also then to be jointly liable for the equitable compensation? They would pay different interest.
Yes. My lord, absolutely, this is a submission I'm going to make later on, but let me make it now. It absolutely doesn't follow in my submission that because the measure of someone's liability is the same as the measure of someone else's liability, that the interest that can be awarded against that person must be the same as the interest that can be awarded against the foreign person. These are 2 separate jurisdictions. The one is a jurisdiction to award equitable compensation, which is determined by general principles, which of course change depending on the particular case in which the claim is made, and the jurisdiction to award interest, which is governed by the pronouncements of the House of Lords in the 2 cases that I've referred to. There was an attempt in 2005 to widen the scope of compound interest so that it was generally available in cases of fraud, and it could have been invoked if that had been permitted. It might have been available in our case, but it failed. And Lord, that's in the bundle of authorities in volume 4 of the bundle. It's the case of Black and Davis. Could I ask your lordships to look quickly at that? Bundle 4, tab 33. And for my Lord Justice Birss, it's at page 1360. That was a claim for damages for deceit. Mr. Justice McComb had held that there was no jurisdiction to award compound interest on common law damages for deceit, and this court agreed with him. And if I could pick it up at page 1399, it's in the judgment of Lord Justice Waller. Could I invite your lordships to read from paragraphs 82 to 86, please?
When you say 86, do you mean 86 or do you mean 87?
I'm so sorry, but I didn't quite hear you.
You said read up to page 86, paragraph 86.
I was going to take. Why don't we read? Let's read 87 then. Yes, that makes sense, doesn't it? I can make my thunder after your lordships have read the paragraph. So, Lord, two, in my respectful, very helpful points can be derived from this case. First of all, the penultimate sentence of paragraph 87. So far as this court is concerned, that is an end of the compound interest question. I hate to belabor a point, but it really is an important point to make. This court is bound by the decision as to the scope of the jurisdiction of compound interest that was made by the majority of the court, by the majority of the House of Lords, in Westdeutsche Landesbank. That's the first point. The second point is there's a helpful explanation of what the fraud category, your Lordship will recall there are two categories two cases where compound interest can be awarded. The first one, the fraud one, there's an explanation as to what it means. That is to say, a case where money has been obtained and retained by fraud, in other words, where the fraudster has had in hand a fund which he has or is deemed to have made use of for his own benefit. And Lord, that makes good the point that I sought to make on the basis of Lord Denning's judgment, in relation to which my Lord Justice Newey picked me up quite properly, because it's not what Lord Denning said. This is being said by Lord Justice Waller here. And in my submission, it must be right. It's because the fraudster has got the funds. The fraudster in many cases, the fraudster will be a fiduciary, but he may not always be a fiduciary. But even when he isn't, the court doesn't want him to have his profit, to have a profit. An important predicate for both of the categories, a fundamental predicate in my submission, is that what you in a trust situation, one has a situation where a trust asset is being held by the wrongdoer, whether a fraudster or a fiduciary, and the fraudster or the fiduciary has the ability to make a profit from the trust asset, and compound interest is designed to ensure that he doesn't end up making any such profit. However, we then come to Bank of Ecuador and Conti Corp. That's in Bundle 8, behind Divider 56. It's a decision of the Privy Council. Facts aren't important. What is important is a very brief passage in the consequentials judgment. The reason why, there is a law report which contains the judgment in the judgment of the board in the substantive case. But the reason why there isn't a law report in the bundle is because that law report doesn't include the consequentials judgment. It's only this document that does that. And if I could ask your lordships to go to page 340, I'm so sorry, I've got the wrong. Do I have the wrong? It's a paragraph 183 to 185.
Page 3000.
It's page 3006. Well, perhaps it starts at. The judgment starts at page 3005. But the arguments and the conclusion are at page 3006. Could I ask your lordships to read paragraphs 183, 184, and 185?
Yes.
The reasoning is, in the context of such a large question, It's disappointingly brief, but it appears to be encapsulated in 2 sentences in paragraph 185. First is that in Novaship, the Court of Appeal has held that both knowing recipients of trust property and dishonest assistance of breaches of duty by a fiduciary are liable in equity to account for unauthorised profits. And the second sentence reads, in this context, the court refused to distinguish between the liability and equity of the fiduciary and that of a knowing recipient or a dishonest assistant. So, Novaship has changed the law, point number 1, and it's changed the law to assimilate the liability of knowing assistants, knowing recipients and dishonest assistants for profits with the liability of fiduciaries for profits. Full stop. Now, if I could take it in stages, knowing recipients are treated as trustees of the funds they've received, as we've discussed today and yesterday. It can be liable to account for the profit for the profits on those funds. But Novaship isn't about knowing recipients. Its decision concerns only dishonest assistants. So let's consider dishonest assistants. Let's say some general points about dishonest assistants. First of all, their liability is not receipt-based. They have not received any fund. They have not made use of any fund. They have not made any profits from the use of any fund belonging to the beneficiary. If they have made profits, it is from a different source. It might be a money launderer fee. Take the present case. In the present case, Mr. Ruhan obtained £102 million, which belongs in equity to HB2. Mr. Ruhan made use of the £102 million, seeking to make a profit. There was clearly a basis for awarding compound interest against him, which in due course happened. The interest was payable naturally on the amounts that he used, namely the sum of 102 million. Compare Mr. Ruhan's position to Mr. Stevens. He never received the 102 million. He never made use of it. He's not accountable for its use. All he received was a fee amounting to £1.5 million. The judge decided that if HB2 elected, he would have been liable for that fee. But my question then becomes a forensic one. Why should he pay interest on £102 million? Compound interest on the sum of £102 million. It's difficult to see because the reasoning of his lordship is so brief, but I apprehend that Lord Mance's answer might be because this court in Novaship refused to distinguish between the liability and equity of the fiduciary and the liability and equity of the dishonest assistant. But there's a problem, in my respectful submission. With the greatest deference to Lord Mance, the passages from the judgment in Novaship that we have seen demonstrate that the court took great care not to assimilate the liability of the fiduciary for his profits with the liability of the dishonest assistant. The court treated the dishonest assistant's liability in a way that was very different indeed from the way it treats the fiduciary's liability. And it did so explicitly on the basis that a dishonest assistant wasn't and should not be treated as if it were a fiduciary. So, first of all, it held that a dishonest assistant is not automatically liable to account for profits, but what's required is a strong exercise of discretion of the sort seen in Attorney General and Blake for an award for breach of contract. Secondly, if the court exercises its discretion, it doesn't apply the causation and remoteness rules that are applicable as against a fiduciary. It applies the common law notions of effective cause, and it imposes the common law requirement of reasonable foreseeability. And that has a practical impact here. If one goes back to the facts of this case, one can be said to have assisted a fiduciary in disposing of his profits. And in the equitable sense, one can therefore be said to be liable for the consequences of the assistant, of the fiduciary's breach. But if the dishonest assistant merely helped the fiduciary in taking an opportunity to dispose of profits, that would not ordinarily be regarded as constituting the effective cause of the disposal of the profits. There is, in Novoship itself, we didn't go to the relevant passages in the judgment yesterday, but in Novoship itself, that distinction is made between giving someone an opportunity to make a loss by your own decision and actually causing the loss to have been suffered. But there's a third difference, and this difference is so profound it puts the others in the shade. If the court exercises its discretion to hold the dishonest assistant liable to account, it doesn't hold him liable to account for the profits made by the fiduciary. It holds him liable to account only for his profits. Those profits will invariably be very different. In this case, the difference between 102 million and 1.5 million. The underlying, I'm doing the best I can, and I may be doing Lord Mance a grave disservice because his reasoning is so brief, but the underlying rationale of his approach seems to be that now it's been established that both a fiduciary and a dishonest assistant have coextensive liability to account for profits. Then it follows that as a fiduciary is accountable for profits, so he can be ordered to pay compound interest. In the same way, as the dishonest assistant is liable, so the dishonest assistant can be ordered to pay compound interest. But in my very respectful submission, I'm very conscious of how easy I'm making this seem, but it is my duty to make the submission. There is a fallacy in the reasoning. The dishonest assistant isn't liable to account for the same profits for which the fiduciary is liable to account. And the liability itself is very different, and it stems from very different principles. It's only by wrongly treating the dishonest assistant as accountable for the amount that's been taken by the fiduciary, or rather accountable for the profits made by the fiduciary on the amount that's been taken by the fiduciary, that it's possible to justify an award of compound interest against him. But we know that that's not the law. The dishonest assistant isn't liable for the fiduciary's profits. So it wouldn't be right to make an award of compound interest which is designed to strip him of those profits. Those are not profits for which he's responsible. Now, Lord, that really is the kernel of my submission.
And just so I understand the significance of all this, assume for the moment that you failed on grounds 1 and 2, then you accept that Mr. Stevens could be held liable for simple interest, but not for compound interest.
Yes.
And the judge ordered 2.5% over base, which would then apply to the simple interest rather than the compound which he ordered.
Lord, I'm afraid
there's no reason to revisit his conclusion rate.
I confess I haven't turned my mind to the actual order for simple interest that should be made. I'm sorry not to. Perhaps I need to look at that and revert.
And secondly, suppose you were successful on one of the earlier grounds of appeal, so that Mr. Stevens was not liable on a compensatory basis. He would then be entitled. The claimant would then be entitled to re-exercise its election, so that it could ask that Mr. Stevens account for his profit.
Yes.
So you say he wouldn't be liable for compound interest even on that?
Yes, because in relation to even those profits, he's not a fiduciary.
Yeah.
He's not a constructive trustee of those profits, I could add, although it doesn't help the analysis. Yes, I've made my submission. He's not a trustee, nor is he otherwise subjected to fiduciary obligations in relation to his role or in relation to the profits he's made.
And on that, even you would say that a narrow reading of what Lord Mance was saying in 185 would actually mean he ought to be able to be made liable for compound interest. But you say that's not, we've got binding authority that that's not right.
Yes, absolutely. And if you, I think I would say that if this court were to award compound interest in relation to the 1.5 million, it would be making an award that's effectively penal in the way that Lord Denning said one shouldn't do.
I mean, obviously the arithmetic would come out at a much smaller number, but the principle is the same.
Yes.
Yes.
Lord, I should add something, make another constitutional point. I'm sure it doesn't need to be made, which is that obviously the judgment of Lord Mance isn't binding on this court. Indeed, this court is bound to follow Lapintada and Westdeutsche. Your lordships, I imagine, will be familiar with the case of Willers and Joyce, which holds that, if you recall, it used to be thought that in circumstances where the Privy Council had suggested that the law had developed in a way that was inconsistent with binding authority, it was open to the English courts to adopt the Privy Council's view if it was a foregone conclusion that when the point ultimately went to the Supreme Court, that is what the Supreme Court would decide. The Supreme Court has now decided that's not right. In circumstances where there's a binding authority, English authority on a point, that point is absolutely binding, and it's not open to a lower court, below Supreme Court level, to depart from it for any reason. For the reason that the Privy Council has changed its mind, as it were. And perhaps we should look at that very briefly. It's in Bundle 7, behind divider 46. The case is called Willers and Joyce. I'm afraid that the law report of that case isn't in the bundle. We handed up the law report yesterday, however, if your lordships would care to see it. It may not be necessary, it's only a brief passage.
Yeah. I'm sorry, where are we now?
Willers and Joyce. Bundle 7, tab 46. Thank you. Oh, I'm so sorry. If your lordship would like to see a proper law report of the decision, we have copies.
As you've got them, yes, please.
Could I?
I see Lord Mance also refers to the Clef Aquitaine case.
Yes.
Have we got that? Or is
No,
there
that's not in the
anything
bundle.
it?
Lord, I've read it. It was a case in which the party argued that it was necessary for there to be a fiduciary relationship before any award for compound interest could be made. And on the facts of the case, that submission was upheld. But if your lordship would wish to see it, certainly we could make it available. But I didn't. My judgment was that it didn't advance the debate. The relevant paragraphs, paragraphs 16 and 17 of the judgment, where Lord Newberger, with whom the other members of the court agreed, said, "There is no doubt that unless there's a decision of a superior court to the contrary effect, a court in England and Wales can normally be expected to follow a decision of the Judicial Committee of the Privy Council, but there is no question of it being bound to do so as a matter of precedent. There is also no doubt that a court should not, at least normally, follow a decision of the Privy Council if it is inconsistent with the decision of a court which is binding in accordance with the principles set out above. 17. The difficult question is whether this latter rule is absolute or whether it's subject to the qualification that it can be disapplied where a first instance judge or the Court of Appeal considers that it is a foregone conclusion that the view taken by the Privy Council will be accepted by the Court of Appeal or Supreme Court. There are decisions of the Court of Appeal which support such an approach, and some examples are given. And then here's the key point. Nonetheless, I have concluded that it is more satisfactory if, subject to one important qualification which I deal with below, the rule is absolute, i.e., that a judge should never follow a decision of the Privy Council if it is inconsistent with the decision of a court which is otherwise binding upon him or her, in accordance with the principles set out above. Your lordships need not look at the principles, they're pretty clear, they're pretty trivial. And if one goes over the page to the qualification, it's where his lordship suggested a procedure by which the Privy Council can effectively change English law. Could I invite your lordships to read paragraphs 19 to 21? So, where it's thought that the Privy Council might decide to depart from a binding decision of an English court on English law, there is a special procedure pursuant to which a special panel of the Privy Council can be constituted, and it can give a special direction to the effect that its decision should be regarded as also reflecting English law as well as the law of the jurisdiction in relation to which the Privy Council is making its decision. Of course, for present purposes, the important point is no such special panel was constituted and no such direction was given in Conticorp. And in my submission, therefore, I don't say it can be ignored, but I say it has no weight when compared with the binding nature of the authority constituted by Westdeutsche Landesbank. Now, the respondent relies upon a series of first instance decisions in which compound interest has been awarded against dishonest assistants, I'm so sorry. Most of them were based on concessions, and the rest were largely based on the brief comments of Lord Mance that I've adverted to. And in none of those cases were any of the points that I have made to your lordships, none of them were discussed. So it's to be, I apprehend, that none of them were raised. The most substantial decision in this regard is the decision of Mrs. Justice Cockerell in FM Capital Partners and Marina. That's in the authorities bundle 7. And that's the last last authority I'll be taking you to.
So bundle 7.
Bundle 7, behind divider 47. And the relevant page in the bundle is page 2433. And if I could invite you to read pages 243 to 2435. I didn't say that clearly. 2433 to 2435 to yourselves, I'd be grateful. Lord, I would make three observations about the judgment. First of all, there is no explicit reference to La Pintada or Westdeutsche, although to be fair to her ladyship, in paragraph 30 she does refer to the two classes. But it would appear that there was no argument that she was bound by Westdeutsche such that it wasn't open to her to come to any different conclusion. And in my respectful submission, for the reasons I've already submitted, counsel in that case was wrong not to make that submission. Secondly, you look at paragraph 39, you see that Mr. Omura, who was counsel...
Sorry, did you say 39?
Paragraph 29.
29.
I'm so sorry. It was my fault. It reads, Mr. Omura, who was the counsel or would have been the defendant, Mr. Omura acknowledges the thrust of the case of Central Bank of Ecuador and Conticor, whereby reference to the judgment of the Court of Appeal in Novaship, the refusal in that case to distinguish between the liability and dishonest assistance of a fiduciary and a non-fiduciary assister was equally applicable to the discretion to award compound interest. Well, there are a number of problems with that. First of all, for the reasons I've already submitted, counsel was wrong to acknowledge the thrust of that. He was absolutely wrong. And in acknowledging the thrust of that, he was making a category error. In fact, Novaship did refuse to distinguish between the liability of a dishonest assister and the liability of a fiduciary for the three reasons that I've already identified. Fundamental reasons.
I think you said did refuse to. Should that have been refused?
What I'm perhaps
you say there were three distinctions drawn.
They didn't assimilate
Yes.
their approach, the approach they adopted when determining the liability of dishonest assister was very different from the approach that is adopted when determining the liability of a fiduciary. I'm grateful for your Lordship's clarification. There wasn't a refusal to distinguish. There was a very careful distinction drawn. My Lord, further, and this is a small point, but the learned judge seems to have thought that the distinction was between the liability and dishonest assistance of a fiduciary and the liability in dishonest assistance of a non-fiduciary. That was not what Novichep was talking about. But that's a small point. The important point is the thrust of Central Bank of Ecuador and Conti Corp should not have been acknowledged at all. And then my third submission arises on paragraph 32 of Her Ladyship's judgment, which is on the next page. We go to Roman 3. It says, however, there is a discretion to award compound interest against a non-fiduciary dishonest assistant. That is now clear from Novichep, where the liability of both fiduciary and non-fiduciary to the remedy of an account of profits was settled. Well, that seems to proceed upon the supposition that the fiduciary is liable for a given amount of profits and the non-fiduciary dishonest assistant is liable for the same profits. And that's not what Novichep decided at all. Her Ladyship then concludes in paragraph 33 that the balance of authority now favours the view that an award of compound interest can be made against a dishonest assistant. Lord, in relation to that, Novichep doesn't support that view. Conti Corp could be said to support that view, but Conti Corp isn't binding on the court. In fact, it cannot depart from, or cannot permit this court, or any court, English court, to depart from binding House of Lords authority. In my respectful submission, therefore, read carefully, Her Ladyship's judgment doesn't grapple with any of the points, any of the problems I've identified in my submissions, and it doesn't take matters further. I was then going to make a submission to your Lordships about the submission that because of the accessorial nature of the liability of the dishonest assistant for compensation in equity, it doesn't follow that the liability for compound interest is similarly accessorial, but your Lordships have already had that submission from me. And unless I can assist your Lordships further, those are my submissions.
Thank you very much, Mr. Garrobinson. Mr. Pickering.
My Lords, in response, we propose to deal with the appeal in the same order as my learned friend. My Lord, starting then with ground 1, we propose to deal with this in 6 parts. First, I propose to give a brief chronology of events. This is relevant for a number of reasons. We appreciate the court is familiar with the general background, but it is relevant for a number of the arguments, including but not limited to my learned friend's separate and distinct point. My Lord, secondly, we propose to deal with a number of what we describe as overarching observations, some general submissions which permeate through our submissions in general. My Lord, thirdly, we propose to take you to Lordships to some of the authorities. My learned friend has taken Lordship to many, and I don't propose to repeat, but there are some additional authorities or some different emphasis in certain cases. But fourthly, I then propose to make a brief analysis of the facts in the light of those authorities. Fifthly, I propose to deal with the separate and distinct point, which is probably the key issue put forward by the second defendant. And Lord, sixthly and finally, it's our additional ground as set out in the respondent's notice. My Lords, perhaps I can start then by way of the chronology of events. And by way of broad overview, the matter can, of course, be considered in stages. Yesterday and this morning, no doubt by way of a shorthand, reference was made to stage 1 and stage 2. But for present purposes, we respectfully suggest that it's more accurate and probably more realistic to consider the chronology in 4 key stages. And perhaps the court would allow me to at least make my run through the chronology on that basis. Well, stage 1, the starting point, is in April 2002, and HP2, the company, it acquired the 3 Hyde Park hotels.
Sorry, I missed the beginning of that sentence. April 2002. Sorry.
April 2002.
Yes.
HP2, the company,
Yes.
the claimant, it acquired the 3 Hyde Park hotels. In other words, the hotels belonged both legally and beneficially to the company. Mr. Ruhan was, of course, a director of HP2. Mr. Ruhan was not strictly speaking a trustee of the hotels because they belonged legally and beneficially to HP2. But of course, he had, to use the language of the authorities, a trustee-like responsibility in relation to those hotels. Well, that's stage 1. HP2 owns the hotels. My Lords, we then move on to stage 2. This is March 2005. This is when the self-dealing transaction took place, whereby HP2 sold the hotels to Cambula Madero, but as the judge found, as Mr. Ruhan's secret nominee. Lord, the consideration, as your Lordships have heard, was £125 million. But there is some relevance to this. It was apportioned between the 3 hotels. The Lancaster Gate Hotel, £56 million of consideration was apportioned towards that. And in relation to the Kensington Palace and Kensington Park hotels, they were sold together, or considered together, and they were considered for £69 million consideration. So the total was £125 million, £56 million allocated to Lancaster Gate, and £69 million towards the 2 Kensington hotels. Lord, uncontroversially, there was no disclosure by Mr. Ruhan to the other stakeholders of his interest on the other side of the deal. The fact that he was, in fact, the nominee, that Cambula Madero was his nominee. Where, however, there may have been a bit of confusion is what the judge did or did not find in relation to what would or would not have happened if there had been a disclosure. Well, Lords, I'm not sure if anything actually turns on this in practice, but since it's been discussed a few times, it may be useful to find out, to review what the judge did and didn't actually find. Yes. If your Lordships have the judgment, it's in the core bundle, page 166. Your Lordships will see, just above paragraph 190, a subheading, Mr. Ruhan's motivation. 190, HP2 contends that Mr. Ruhan's motivation was the desire to obtain all, or at least a greater share, of any profit to be made in the redevelopment. Lords, that's all I need to take you to that. 191, Mr. Ruhan has advanced a number of answers to that point. I can skip 192, but 193. It was said that if Mr. Ruhan had wanted to try exploiting that commercial opportunity, there was no reason why he should have done so secretly, because the evidence establishes that the other stakeholders would have been open to a bid by him. The defendants point to the email from Mr. Merchant of Morgan Stanley, the 24th of May 2004, which indicates that he would have read any bid from Mr. Ruhan for the Hyde Park hotels with interest, and the fact that Mr. Ruhan did acquire the Scepter hotels, which has not formed part of the hotel note issue, as part of the equitisation. It is also the case that before the equitisation, the fact that Mr. Ruhan had not ruled out a bid for the Lancaster Gate Hotel had been mentioned to GMAC and is referenced to in the email of the 17th of September. So that was what Mr. Ruhan had said. That's why it wouldn't have mattered, and there was no need for him to be secret. 194, and this is the judge's view on that. However, I do not think that Mr. Ruhan derives much assistance from discussions before the equalisation agreement reducing his equity in HP2 to 33.3% had been agreed, nor to communications with Morgan Stanley alone. I'm satisfied on the evidence that there was real sensitivity on the part of both Thistle, that was one of the stakeholders, and some of the note holders as to any bid involving Mr. Ruhan. I've referred above to the concerns expressed by UBS on behalf of some of the note holders on the 7th of December and the confirmation Mr. Ruhan then gave at the meeting on the 13th of December that he was not associated with any bidders. 2. Mr. Ruhan felt it necessary to confirm the position again in emails with Thistle in February. 3. Mr. Catamola of Thistle raised this issue in February and a similar issue with specific reference to Cambulo on the 30th of March. Given Thistle's clear concern on this issue, the defendant's submission that it is unclear why it is said that Mr. Ruhan kept his supposed interest in Cambulo secret from Thistle, or why there was any to do so, is surprising. And 4. The evidence of Mr. Wilcox at GMAC on this issue, representing an instinctive reaction of an experienced professional, was clear. He said an offer from Mr. Ruhan would not have been acceptable because generally you'd want to be confident they're being sold to an independent third party. That an offer from Mr. Ruhan would have given concern and led to caution. I accept that evidence. So 195, it is clear therefore that any bid from Mr. Ruhan would have attracted considerable scrutiny. That of itself would at best have prolonged or complicated the transaction and might have led to the inclusion of terms adverse to Mr. Ruhan's interests, such as a profit commission for the other stakeholders. It would have led to the close scrutiny of Mr. Ruhan's financial position, rather greater scrutiny than ECD and Cambulo Madeira bids appear to have received, and how quickly it could complete any bid. And it would have taken Mr. Ruhan out of his central role in receiving and commenting on what would, on this hypothesis, have been rival bids leading to a loss of information control influence. For these reasons, I'm satisfied that if Mr. Ruhan was interested in acquiring the high-powered hotels in an attempt to exploit the risky but potentially highly rewarding development opportunity that they presented, he had ample motivation not to approach HP2 and the note holders bidding in his own name. The suggestion this argument is not open to HP2 because it's not put in terms is without merit. Well, that shows, first of all, the judge's view as to Mr. Ruhan saying that there was no need for him to be secret. Well, we can go further, however, to paragraph 222 and 223. Was it page
22233 is really the judge's final view on this, isn't it?
It's 223, my Lord, yes. We can see under the subheading HP2's claim for account of profits. In fact, I can go straight to 2233. Equally, however, the evidence before me does not enable me to conclude that if Mr. Ruhan had disclosed his interest in Cambulo Madeira to HP2, the Cambulo Madeira transaction would have proceeded on the same terms as it did. As I've indicated, there are a number of possible issues which might easily have arisen in that counterfactual, which Mr. Ruhan's decision to act through a nominee was designed to avoid. The reality is that it is simply unclear on the evidence what would have happened if Mr. Ruhan had acted as he was obliged as a fiduciary to act. The lack of clarity is not something that provides a basis for refusing to order Mr. Ruhan to account. Well, that's pretty much how he put it on in opening. We did not advance any positive cases to what would have happened. And the judge made the findings that he did there. So certainly it's not right to say, for the record, that if there had been a disclosure, the deal would have gone ahead regardless.
I mean, the difficulty with that is that the judge says, well, he doesn't know what would have happened. And he says, well, you haven't advanced a case that you'd have got a greater price. So does it really matter?
Well, it doesn't. And I started this observation by saying it probably doesn't matter.
Yes, I thought.
We made a conscious and deliberate decision not to advance a case based on the authorities on the case which we were running. I simply wish to make it clear that there have been some suggestions that there was a finding and the deal would have gone ahead regardless of the disclosure. It's simply to there was no positive finding either way. The judge simply felt that he was unable to say what would have happened. Well, Lord, in any event, returning to this stage 2, as I describe it, the sale to Cambula Madeira. That sale took place, as I say, in March 2005 for £125 million. Because that sale amounted to a self-deal in breach of fiduciary duty, under well-established case law, the hotels, although now legally owned by Cambula Madeira as Mr. Ruhan's nominee, they were held on trust for HP2. I will be coming to the case law shortly. Moreover, and this is uncontroversial, they were held on constructive trust of the first type, as described by Lord Justice Millett, as he then was in Paragon. So, my Lord, in short, immediately after the self-dealing sale, Cambulo, as Mr. Ruhan's secret nominee, held the hotels on a Type 1 constructive trust for HP2. Lord, that's stage 2. Stage 3, that's the on sale of the hotels to independent bona fide third parties. In fact, this took place in 2 tranches. First, the Lancaster Gate Hotel, and then secondly, the 2 Kensington hotels together. As for the Lancaster Gate Hotel, this took place in August 2006. If your lordships have the judgment open, perhaps you could turn to page 130 and the judgment at 85. I refer to the paragraph more for reference. There's no doubt that the purchaser was a bona fide purchaser of value. The sale price was £67.5 million. And after taking into account of the money which Cambulo had paid for the hotel, which was £56 million, and various other expenses of £3.74 million, the Lancaster Gate on sale realised the relatively modest profit of £7.76 million. And one can see that summarised in the first sentence of paragraph 85. The real profit wasn't in fact made until a fair bit later in relation to the Kensington hotels. Now, my lord, in relation to the Kensington hotels, this was in March 2008. So, over 3 years after the self-dealing sale. The self-dealing sale was in March 2005. The 2 Kensington hotels were on-sold in March 2008. And in the intervening period, various things have happened, not least the entering into of a joint venture with the Candy brothers and various corporate entities set up by them. My lords, in any event, the Kensington hotels on sale took place. The proceeds of sale received by Cambulo were £94.5 million. I don't need to take your lordships to it, but if your lordships note, the precise mechanism of how that's calculated is set out in footnote 5 of our skeleton, page 2. It's set out there in some detail. But in short, Cambula Madeira was paid a sum from the joint venture company, joint venture with the Candies, by way of a dividend. And after sharing with a partner company, the net cash actually received by Cambula Madeira by way of a dividend was £94.5 million. For present purposes, the precise mechanism isn't relevant, but it's there in footnote 5, should your lordships wish to see it. My lords, again, it is uncontroversial, but it's worth stating. that sum of £94.5 million represented the traceable proceeds of trust property, i.e. the hotels, or at least two of the hotels. And again, uncontroversially, that sum was itself also trust property. In other words, now at stage 3, after the on-sales, Cambulo Madeira, as Mr. Ruhan's secret nominee, now held that cash on constructive trust for HP2. And again, it was a type 1 constructive trust. So, pause in there to summarise. As at 2008, there was a type 1 constructive trust. The trustee of the constructive trust was Cambulo, as Mr. Ruhan's nominee. The beneficiary of the constructive trust was HP2, the company. And the trust property within the constructive trust was cash deriving from the proceeds of sale of the hotels of about £100 million. Well, that's stage 3. So stage 1, HP2 owns the hotels. Stage 2, HP2 sells the hotels to Cambulo Madeira as Mr. Ruhan's secret nominee. And stage 3, a few years later, the nominee company sells them on. Then we come to stage 4, the final stage.
Sorry, Mr. Pickering, can I just make sure I've understood something? Did the 94? I thought the 94 million was profit. In other words, that if you look at it purely from Mr. Ruhan's point of view, and forget about the detail, I appreciate that maybe the answer is you can't forget about the detail. But he, via a nominee, bought the hotels for 125 million, but sold them for 200 and whatever it is, 37 million. That's right.
Lord, it is the profit which was made.
The profit is not the value of the hotels. The way you were speaking a minute ago sounded like you were saying this is actually the hotels. This is now the hotels have been converted into £94 million.
My Lord,
that's
no,
not the same thing.
My Lord, no. Your Lordship is absolutely right. It's the profit.
This is profit. So that the 300, presumably somewhere, the 320 million that came into Cambulo for these hotels, some of it went to pay the proceeds that were paid to HB2.
Lord,
Not pay the proceeds, sorry, pay for the cash that was paid to HB2.
Lord, effectively, yes. Some of it went to the joint venture company with the Candies. There were other expenditure. But this represents the net, the profit.
It is profit.
It is profit.
I don't remember, the title to the hotels didn't pass into the joint venture company, or did it pass into the joint venture company? Who affected the actual sale?
It was a joint venture company.
So title had gone from Cambulo Madeira to the joint venture company. Yes, I follow.
My Lord, yes, there were the actual structure. Perhaps you can find it. It's a subsidiaries of the joint venture company, my Lord. I think nothing tells the precise mechanism. If your Lordships have our skeleton to hand, page 2, footnote 5. So on the 25th of March 2018, that should be 2008, that's a misprint. On the 25th of March 2008, CPHL, which is the Cambulo Candy joint venture vehicle, completed the sale of the Kensington hotels to De Vere Estates, that's the third party, 320 million. After deductions, dividends of £115 million odd were paid to Cambulo, and 100 million odd to the Candies company, CPC Group.
Yes.
A proportion of the profits due to Cambulo in turn paid to Wellard, that's a partner company, and Mr. Stevens accepted that the profit which remained was approximately £94.5 million, albeit held as nominee. My Lord, when I made reference to the trust property earlier, that was a reference to being traceable property. So as at stage 2, Cambulo acquires the 3 hotels. It has legal title. At stage 3, it sells them in 2 tranches. It receives money, the £94 million, £94.5 million, and that is it is the profit, but they're directly traceable, and therefore are held on trust. My Lord, so now Cambulo has the cash, and we come to stage 4. And following that, stage 4, Mr. Ruhan then uses that cash, HP2's traceable property, to his own end. In other words, HP2's trust property was spent. And they were spent in such a way that they were no longer traceable. My Lords, it's quite telling to note how this happened, how the money was spent. My Lord, perhaps we can go back in time slightly to December 2007, so about 3 months before the sale of the Kensington Hotels. In the judgment at page 141, the position is summarised paragraph 117. So, as I say, to give it context, this is about 3 months before the Kensington Hotels were in fact unsold. And what the judge found in his judgment, on the 21st of December 2007, Mr. Ruhan's company, BTH1, obtained a loan of $141 million from Investec to support the Qatar project. And that loan was known as the Mood facility. The security which was provided for that facility included a charge over the shares of Eurostates. And we're pausing there. Eurostates was the holding company of Cambulo. Again, nominally owned by Mr. Stevens. And also Wellard, which was the company owned by his brother. Returning to 117. Security provided that facility included a charge over the shares of Eurostates, through which interests in Kensington Park Hotels were believed to be held. HP2 contends that this reflected what it claims to be the reality of the position, that assets nominally held by Mr. Stevens were in fact Mr. Ruhan's, and it's for that reason that the assets were made available as security for a loan made in relation to one of Mr. Ruhan's projects. I probably don't need the rest of the paragraph. So, my Lord, in short, Mr. Ruhan had a project in Qatar. He borrowed money, $141 million, from Investec for the purposes of that project, his project. And that was 3 months before the Kensington Hotels were sold. But the security for that, the security which Investec extracted, was a charge over Eurostate, which is Cambulo's parent company, and effectively, therefore, the hotels. Now, Lord, moving on from there, shortly after, as I said, on the 25th of March, the Kensington Hotels were sold, and the cash HP2's traceable property was realised. But if your Lordship could turn to page 149 in the judgment, and to paragraph 139. Your Lordship should see a subheading, the repayment of the Mood facility. The sale of the Kensington Hotels triggered an obligation to repay the Mood facility to Investec. So, Lord, I probably don't need to go much further into that paragraph, but there's a reference for your Lordship should you wish to read that. So, in short, Cambulo Madeira used some of HP2's money it had just received to repay the mood facility. Now, Kambulo was, of course, Mr. Ruhan's secret nominee, but on the face of it, it was all done and authorised by Mr. Stevens. So, my Lord, just to summarise, the Kensington hotels are received by Kambulo, nominally owned by Mr. Stevens, and very shortly afterwards, Kambulo, acting nominally through Mr. Stevens, uses that money, indeed is contractually obliged to under the mood facility, to repay Mr. Ruhan's loan. And indeed, Euro then steps in to the shoes of Investec. Now, my Lord, what can be seen here? This is not a case of assistance by Mr. Stevens because he had been a front man 3 years earlier, at the time of the Kambulo Madeira sale in 2005. This is something new and different altogether. In fact, it doesn't stop there. After paying off the mood facility, there was, which was roughly $140 million, there was still cash. There was some 19.9 million pounds odd left. So after paying off the facility, there was still cash, HP2's traceable property available. If your lordships would look please at paragraph 141. So far as the mood facility itself is concerned, Eurostates, Kambulo's parent, nominee on Mr. Stevens, assumed Investec's position as lender to the Qatar project, executing a new facility as of 2nd of April. By the end of April or May, the security which Investec had enjoyed over the Qatar assets was renewed for Eurostate's benefit. Writing to Mr. Ruhan on the 14th of March 2010, Mr. Stevens was unsure whether or not Eurostates had taken over the benefit of the Investec security, writing, I believe that Eurostates basically took over the security pack that had been put in place for Investec end of 2007. 142. The parties are agreed that in the event that there was some £19.9 million left over from Eurostate's share of the proceeds of sale of the Kensington hotels after paying off the mood facility. And this amount was not returned to Eurostates, but used for the purpose of Mr. Ruhan's businesses. Mr. Stevens gave evidence that this was by way of a further, wholly unsecured loan by Eurostates to the Qatar projects. I was told it was needed for working capital. Beyond being used for working capital, I do not know what specifically they were used for, as that was something the borrower had done. I was taken to no documents relating to the circumstances in which any such loan was sought, or what was said about what the funds were used for. And at 143, just the first sentence, the effect of Eurostate's discharge of the mood facility and the further Eurostate's loan is that the entirety of Eurostate's return from the Kensington hotels was committed to Mr. Ruhan's Qatar project. So my
We
Lord,
need to find a moment. Sorry, complete what you were going to say.
no, my Lord, that rather speaks for itself. So the entire £94.5 million, which came into it came to Kambulo Madeira, it was applied, no doubt on the instructions of Mr. Ruhan, but with the assistance of Mr. Stevens, who was a front man, it was applied to Mr. Ruhan's projects. Most of it paying off the mood facility, and then a bit later, the final £19.9 million being advanced to the Qatar project.
I mean, most of these paragraphs seem to go to whether Mr. Stevens was a nominee, which is now water under the bridge. What is the significance of all this for our purpose? Perhaps you could tell us that after the adjournment.
Well, Lord, I'd like to do something.
And just again before we break, just to complete the story, do we know what happened to the Qatar project?
My Lord, it's a long story which resulted in an 8-week trial was one of the issues. In short, there was no traceable interest for HP2.
Do we know if they were successful or unsuccessful?
the Qatar project.
Yes.
Again, it was. It went through very bad times, and money came out. Mr. Ruhan described it as unmitigated disaster, but a significant amount of money still came out.
Yes, I see.
But in short, it was not possible for HP2 to trace into those monies.
Yeah.
Well, Lord, it was roughly 180 million came out, but none of it was traceable to.
Yeah. Fine. So I think it's about 5 past, according to my watch at least, even if that says it's 8 minutes past. So shall we come back at 2:05?
Christ.